Thank you very much. Thank you, Mr. Chair.
Senator Cotton?
Mr. Rikelman, do we have a violent crime crisis in America today?
I'm sorry, Senator.
Do we have a violent crime crisis in America today?
Senator, I would leave that up to policymakers to decide.
Okay, I would say we do, since murders have increased so much in the last few years. They're now up to levels not seen since the 1990s, in part because of left-wing pro-criminal policies, like the ones you advocated for in your 2007 article in the Baylor Law Review, where you argued it was unconstitutional for law enforcement to log DNA samples from convicted criminals. I know you discussed this a few minutes ago with Senator Grassley. I was watching. I was astonished at what I saw. You claim that you were only talking about one exception to the Fourth Amendment and not the Fourth Amendment in general. That is not true. Here's what you said to Senator Grassley. This is what just moments ago. In the Law Review article that I believe you're referring to, I was only discussing one exception to Fourth Amendment doctrine called the special needs exception. I was not talking about Fourth Amendment law in general. You just said the same thing to Senator Blackburn as well. Twice now you've claimed you were only talking about the special needs exception. But here's your own words in the Baylor Law Review article. The question remains whether the court will uphold the DNA testing statutes under a theory other than the special needs exception. Current precedent does not support the DNA testing statutes under any Fourth Amendment theory. However, given that every federal appellate court that has considered the statutes has found them constitutional, it is more likely than not the Supreme Court will do the same. This article predicts that should the court uphold the DNA testing schemes, it will rely on its line of cases establishing a diminished expectation of privacy for prisoners and those on probation or supervised release. Under this standard, the court should refuse to uphold the statutes as applied to arrestees as opposed to convicted felons. The court should not uphold the DNA testing statutes under any Fourth Amendment theory. So what you said earlier, Senator Grassley, I don't think was a nuanced difference on the understanding of the law. You said that you were not talking about anything in the article other than the special needs exception, but your article tells clearly a different story. Would you like to revise your answer earlier?
Senator, I apologize if I forgot the end of the article. I wrote it, I think, about 15 years ago. My memory of the article was that it focused, and I think its title focused, on the special needs exception to the Fourth Amendment, which is an issue that I had litigated a few years earlier, and therefore my memory of it is that the bulk of it discusses that narrow exception to the Fourth Amendment, which is supposed to be invoked under Supreme Court precedent only in situations when the evidence isn't gathered for law enforcement purposes.
Mr. Rikelman, you're nominated for a lifetime position on a court one step below the Supreme Court. Did you not review your own writings in preparation for this testimony?
Senator, I did look at that article briefly. Again, I wrote it 15 years ago, and my memory of it, including its title, is that it really focused on the special needs exception. Again, I just want to be clear to the committee that I will faithfully follow all Supreme Court precedent, whether it's on the Fourth Amendment or any other part of our law.
I know you wrote it 15 years ago, but you said you looked at it, albeit briefly. I mean, again, this is a lifetime position on a court one step below the Supreme Court. I mean, I think we have a reason to expect you take more care than to review your own record briefly. When litigants come before you, are you going to read their papers briefly or carefully?
I will read them extremely carefully and carefully look up all of the relevant precedent and the record that is in the case.
Let me get to the substance of this argument itself. Do you know what % of convicted criminals are rearrested in the United States?
I do not, Senator.
It's almost all of them. 83% are rearrested within the first 9 years after they've been released from prison. Do you still think it should be illegal to check a convicted rapist's DNA to see if he's, I don't know, raped another woman or committed a murder?
Senator, I think the Supreme Court has resolved the issue, and I will faithfully follow the Supreme Court's precedent in any criminal case that may come before me, and I understand.
You maintain the same personal view that you wrote about in the 2007 Baylor Law Review article and that you misrepresented here today, that we should not take DNA samples of convicted murderers and rapists to see if we can close down other cases or to use in investigations in the future when they almost certainly commit other heinous crimes.
Senator, in that article, I was merely discussing Supreme Court precedent and how it should be applied. That's the only question that I was looking at there. It was not meant to be a discussion of policy, which I leave to folks in your position. And again, I will faithfully apply all Supreme Court precedent, whether it's on the Fourth Amendment or any other area of law.
Well, the folks in my position, at least on the other side, aren't doing a very good job of that, and that's one reason why we have a crime wave across this country.